Hey folks, Massad Ayoob here for the Wilson Combat Channel. We hope you'll subscribe to the Wilson Combat Channel and hit that little notification bell on your screen. That'll let you know when the next knowledge bomb gets dropped by the next guest. I've been asked to talk to you today about one of the most controversial elements in self-defense law, the stand your ground concept. The real controversy goes back to probably mid-first decade of the 21st century. Now, historically, there are many states in America that have never had any sort of retreat requirement in terms of self-defense. And where the term comes from, the citizen had the right, if they were unlawfully attacked, to stand their ground any place they had a right to be, and to respond with whatever level of force was necessary, even if that rose to a level of deadly force. Some states over the years had imposed a retreat requirement. That is, before using deadly force, one was expected to attempt somehow to extricate themselves from the situation. Now, one thing to bear in mind with that, no state, with or without stand your ground, has ever demanded retreat unless it could be accomplished in complete safety to oneself and others. If you didn't find that in their black letter law, that is, their state statutes and state criminal or penal codes, you would find it in the case law, the decisions by the higher courts that guide the lower courts in how the elements of the black letter law are to be applied situationally, case by case. Now, Florida had had a retreat requirement, and the legislators who brought forth the change made it a part of literally a package of reform legislation that did a lot of good things for law-abiding armed citizens. The first of those things was the elimination of the retreat requirement, the rescinding of the retreat requirement, found in Statute 776.012 of the Florida Statutes. One was allowed to stand one's ground if attacked in a public place where they had a right to be, or any place where they had a right to be. Because a package of reform legislation with many different elements can't have many different names, all the other elements were put under what the newspapers and everyone soon called the stand your ground laws. And that led to a great deal of confusion because none of those other elements had to do with the stand your ground principle per se. One element, it had come to the legislators' attention that a politically motivated prosecutor who, let's say, was anti-gun and wanted to dance on the puppet strings of whatever anti-gun billionaire might have donated to their election campaign, were known to wrongfully prosecute, to what's called an unmeritorious prosecution, people who had shot someone in self-defense. They introduced the 776.032, which was the hearing that it allowed for a pretrial hearing, that is a miniature trial, in which the judge would determine whether or not there was a sufficient element of self-defense present. The sufficient element was held to be the preponderance of evidence standard, that is, a greater than 50% likelihood that the defendant had fired in self-defense or acted in self-defense, or simply more likely than not. If the hearing determined that this was the case, that was it. The law said there will be no prosecution on this matter beyond this. It also allowed that if, for example, the prosecutor himself had said, look, this is a justifiable homicide, obviously, we're not going to waste the county's money on it. We're just not trying this case. You could still be sued afterwards. Hell, if you had been acquitted at trial, you could be sued afterwards. And the reason is the different standards of evidence. In criminal court, to gain a conviction, the prosecution has to prove to a reasonable, to prove beyond a reasonable doubt that the defendant was in fact guilty. Now, the judges never seem to put a percentage point on it, what is beyond a reasonable doubt, but many legal scholars and law professors do, and that will range from somewhere between 95 to 99% certainty as a general rule. The reason you're having been acquitted or not charged at all is no defense against a civil lawsuit is that in civil court the standard is different. It's that preponderance of evidence standard of a greater than 50% certainty. Now, what this element did, the 776.032 hearing, or the prosecutor's office issuing what's called a memorandum of closure that was very specific, would bar a civil lawsuit. It could be filed, but it would probably be thrown out in the first motion for summary judgment. And the law said it should be. The reason being that if you have shown more to a greater than 50% certainty that it was self-defense, it's virtually impossible to, show in a criminal court that it was high 90th percentile, that it wasn't self-defense. So basically, the 776.032 was prosecutorial immunity. It also had the element of civil immunity. In 2017, the Florida State Supreme Court threw that element out, and that now is a matter of contention. But right now, and the way I look at it, you no longer have that guaranteed protection against a lawsuit by having been determined that it was self-defense. The memorandum of closure, by the way, when issued by the prosecutor's office, what's called a state's attorney's office there, had to not just say, we decline to prosecute. That could simply mean that, well, we weren't sure we could prove 95% or higher likelihood that they're guilty. And as we've said, that's no bar against a civil lawsuit with the preponderance of evidence standard. What the memorandum of closure would have to say to activate under 776.032, was that this office has investigated the shooting and has determined it to be self-defense or has determined it to be justifiable. But as said, since 2017, that's a bit up in the air and I wouldn't be counting on it. The stand your ground package also reinforced castle doctrine and made it clear in the black letter law that when one was attacked by an intruder in one's home, the home was their castle, they need not retreat, they had the right to self-defense. And that legislative package also made clear that the privilege extended to your vehicle if you were attacked inside your vehicle. Not someone damaging a car, but an attack to an occupied vehicle. So you had many, many different things there, all under the name of stand your ground. Even the attorneys and judges were referring to that 776.032 hearing as the stand your ground hearing, even though stand your ground might not have been at issue at all in the case at bar. The general public totally misunderstood it. Some people on our side, unfortunately, but more the anti-gunners, the prohibitionists, were saying this Florida law says all you have to do is say, I was in fear for my life, and you can kill anyone and get away with it. And that simply was not true and was never the case. I heard one prosecutor actually say that the stand your ground law meant police wouldn't bother to investigate homicides because the stand your ground law would exonerate murderers. And I considered that a blatant insult to the law enforcement community, because obviously homicide, and particularly murder over manslaughter, are among the most heinous felonies that there are. And to imply that the police officers would look the other way or do a haphazard investigation, I thought was absolutely disgraceful. The stand your ground laws basically were the stand your ground elements, 776.012, and the similar laws that were subsequently passed in some other states were a great moral victory for our side. Second, they clarified in the black letter law, where anyone could look it up, you're not expected to retreat, or at least required to retreat, if you're attacked any place that you have a right to be, and you are not the one who instigated the fight. What this did, if you had a politically charged case where the prosecutor, who remember is an elected official, was coming under great community pressure or media pressure to charge someone who had fired in self-defense, the stand your ground law gave them an out and allowed them to explain, look, if you got a beef with this, take it up with the legislature in Tallahassee. I can't violate state law, and here it is in black and white. But it did not so much change the the rules of engagement for the private citizen. The reason being, if any of you watching this were able to walk away from a situation in total safety to yourself and others, wouldn't you have done it? Would you have still shot somebody to death? I can't think of a situation, and I've been asking people that for decades, and none of them have either. But what it did, it was a moral victory. It clarified things as best they could be clarified for the triers of the fact and for the general public. Unfortunately, media interpretation and deliberate misinterpretation by people with political axes to grind have muddied the waters there. I hope this explanation has helped, and if you find yourself in a discussion on the topic, feel free to link to this, and hopefully it will become a little more clear. If it sounds clear as mud, it's because nothing is crystal clear in the law. But I've tried to clarify it for you as best I could. I hope you'll continue to subscribe to the Wilson Combat channel and to press your notification bell. Look forward to seeing you down the road. Good luck, good shooting, stay safe.